The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in 1CA JV19 0078, Joshua G. versus the Department of Child Safety. Judge Campbell will also be participating in this case. She is ill this morning. She will be watching the argument either live streaming or going back and looking at it afterwards. She may be home sleeping, I don't know. Anyway, these proceedings are being audio and video recorded, so we'd ask that counsel identify yourself and your client at the beginning of your argument. Each side has 20 minutes to present argument. Appellant's counsel is reminded that it's up to you to reserve any time if you wish to have rebuttal argument. And with that, counsel, you may begin.
May it please the court, my name is Clark Jones and I am counsel for the appellant father Joshua G. Father's parental rights to his two children were terminated under the 15 months time and care ground pursuant to ARS 8533B8C. The statute specifically requires several things be proven by clear and convincing evidence before a parent's rights can be terminated under that particular ground. Specifically, they have to show that the children have been in out-of-home placement for a period of 15 months or longer, and also that the department has made diligent efforts to provide services reasonably calculated to actually help that parent overcome the deficiencies or obstacles to returning the children. Additionally, the department, if seeking termination under this ground, is required to prove that the parent has been unable to remedy the circumstances that caused the children to remain in an out-of-home placement, and that there's a substantial likelihood that the parent will be unlikely to remedy those circumstances in the near future. Father contends that the termination order authored by the Superior Court was insufficient in several areas, that the department failed to meet its burden on several of these statutory requirements, and that the court's order constitutes an abuse of discretion and should be reversed. Ultimately, Father is requesting that this court reverse the trial court's order and allow him to have more time to participate in services reasonably calculated to assist him in overcoming what remaining burdens there may be to the children being returned to him.
Counsel, I have a couple of questions I'd like to have you focus on, if you would. I noticed that Judge Anderson's order, he makes several findings. Most of them relate to mother. And he makes these findings as it relates under his section for the clear and convincing evidence. Then he makes additional findings under the best interest analysis, which would be by a preponderance of the evidence. If we were to take all of the findings that the court makes, and if you look on page 20 of the order, he makes all of those findings that do actually relate to father, or most of them relate to father, starting mid-page going forward. If we took all of those and put them in a different section, would Judge Anderson have made an appropriate determination for termination?
No, I don't believe so. I think it would certainly read a bit more smoothly, and it would be more clear exactly what findings were made, what were factual findings, what were legal conclusions, and what the evidentiary basis for those conclusions were. But the judge fails, even if you consider that paragraph, the trial court did fail to expressly find that second part of 533B8C, which is that there's a substantial likelihood that the parent would be unable to remedy those circumstances in the near future. I know the department has argued that this court can imply that all necessary findings were made, even if the judge fails to make them. But
doesn't the court essentially make that finding by preponderance in the best interest section? Doesn't the court say they're unable to provide the specialized supervision and care the children need?
I think that can be read as a statement of the facts, the circumstances at the time of trial. Father argues I argue in my first contention that he did actually remedy the circumstances, but my second contention
But assuming he hasn't, you're saying you could still read that as when it says are unable to, doesn't that suggest that not only have they not done it so far, they're unable to do it in the future?
I don't think so. I mean, I think that certainly, if we're just looking at the language and the semantics, that would be a reasonable interpretation of those
But so
words.
if he'd made that finding, the court concludes that there's clear and convincing evidence, or applies the correct standard, not just a preponderance. You're saying that still wouldn't be enough because you're saying are unable to isn't clear enough, that means it only goes to right now, but in the future he may be able to?
That's correct, and I think the statute the statute expressly lists two parts. One, it makes a statement of the present. The parent has to have been unable to remedy the circumstances that cause in the present the children to not be able to be returned. But moreover, there's a requirement that you show that in addition, there's a substantial likelihood that even in the near future he won't be able to remedy those.
Isn't that what that says? Reading it that way, wouldn't it say they have been unable to remedy this, have been unable to provide the specialized supervision and care, as opposed to they are unable? That, I'm not sure how to read that other than as the judge saying they're not going to be able to do this. They haven't and they can't do it, or they don't seem to be able to do it.
Yeah, I see how you would read it that way just based on the language, but my contention is no, that's not what it says. It's very easy, in my opinion, to read that as a statement that today at trial, after considering all the evidence, these parents today are unable to care for these children. But they could go the other way right after that and make a finding that they might be able to remedy that in the future.
Well, isn't the basis for this finding inherent? It's not something that father can necessarily remedy, is it?
No, I completely disagree. For two reasons. I mean, first, this case, throughout the life of this case, the department identifies obstacles to reunification. Father willingly participates in services. The department willingly offers services, and father makes tremendous progress. All of the obstacles that are outlined at the onset of the case and when the supplemental dependency petition are filed are conceded by the department to have been remedied by the time of trial. It's these new concerns, the children's behaviors at the time of trial, and father's ability to understand them and meet those needs, that is really the basis for the termination at the end of the case. My contention is that if father had more time and had appropriate services, actually had assistance from the department, he could have been able to overcome those obstacles. It's telling that these behaviors, they didn't exist at the onset of the case. They were not identified early on in the hearings as the problems or obstacles to father reunifying. The first psychiatric intake for NG, the child NG, wasn't until the end of April of 2018. In June of 2018, her behaviors are still worsening. After the severance motion is filed, they're still worsening. The autism diagnosis for W does not come until January of 2019. And it's in the record that even at the time of trial, the department is still just then trying to get the children in the appropriate autism services. So these developments are coming at the 11th hour. They're constantly evolving, and father did not have an adequate opportunity to address them, to come to understand what those needs are, and to demonstrate that he would be able to meet their needs going forward.
Well, but you're not asserting that these children were perfectly fine at the beginning of the dependency and then somehow turned into autistic special needs children at the end of the dependency. I mean, isn't there a spectrum there somewhere?
Indeed, they had some behaviors. Some behaviors were noted, but father participated in a full parent aid at the onset of the case. The reports are glowing. He completes that successfully. He is able to meet these children's needs. He later participates in a bonding assessment by a psychological professional who observes him, finds that he does a compelling job parenting them. He meets their expressed and unexpressed needs. He's able to soothe them. He's bonded to them. They have a relationship apparent with him. So they definitely did, their needs definitely did get worse as time went on, and they were discovered. Whether they actually worsened or became contracted autism or came down with autism, that's not what I'm saying, but the department, the caregiver for these children, didn't know they had autism until January of 2019. And so whatever needs they had, father didn't have an adequate opportunity to understand what they were, to learn skills to overcome them, and to learn how to meet the children's needs, because he was already facing a termination trial when they're still getting diagnoses dialed down on these children.
But under the statute, we're talking about the parent, once it's determined they're rightfully in care, the clock starts to run, and the parent has 15 months to remedy the situation, correct? Isn't that what the statute is? I mean, it's not 15 months to remedy each thing that happens. It's 15 months total. right?
That's correct. Part of the statute is that 15 months to remedy the circumstances. I don't think that it's certainly uncommon for new circumstances to arise at the 11th hour, and it would, I would argue, be appropriate for the court to make a distinction there. However, in this case, he still didn't have an opportunity. Even with the 15-month limitation, even if it's a cold, hard 15-month limitation, the department has to offer services diligently calculated to help father overcome those specific obstacles. That wasn't offered in this case because the obstacles weren't clear until the very end of this case, until the time of trial. So father still needed more of a chance. He needed to have, if not more time, more help, more resources from the department.
But there's not to put words in your mouth, but doesn't that circle back to the questions that Judge Catania was asking you earlier about it's not only now, it's the future. Can he parent in the future? So don't we need a finding that in fact he can't parent in the future? Because that would extend the 15 months. If the person, you can parent in the future.
Well, there's not a cold hard rule that the rights must be terminated at 15 months. It's if a judge cannot find that a parent's rights can be terminated under that ground unless the children have been in care for at least 15 months. In fact, even in this case, it had been more than 15 months at that point in time. So father's contention is he could have had more time. The statute would allow for more time, and if not more time, more resources from the department to address this. I don't think that the fact that he could not parent, and I would argue that he could parent at the day of trial if the children were put in the home with him with a family reunification team, as was recommended by the DCS supervisor 2 months before the case plan changed to termination and adoption. I would argue that if he had that time, if he had the children in the home, he would have been able to parent.
Wouldn't we defer to the Superior Court if, let's say the Superior Court had said what DCS provided was adequate. They could have done more, but in my view, it was adequate. And I conclude by clear and convincing evidence that father is going to be unable to parent, to cure the deficiencies or to adequately parent in the future. We wouldn't revisit whether DCS should have provided more services, would we?
I'd still ask you to. I may have less of a leg to stand on if he'd made it that clear, but he didn't. And this court is able to review and see whether there's a reasonable evidence to substantiate the court's claim. So I know this court tries to avoid weighing evidence, and it's sort of a fine distinction between weighing evidence and looking to see if there is indeed a reasonable evidentiary basis for the findings.
And we also try to avoid sending something back if it's pretty clear what the result would be. And it seems like if you look at the order as a whole, if the court had simply made findings by clear and convincing evidence, it seems like it's very unlikely that the result would be different.
Indeed, it may be unlikely. Father's contention is if he had a chance to have these kids in his care, as was recommended by the DCS supervisor 2 months before the case plan switch to termination and adoption, he could have been able to remedy these circumstances. And now, with the knowledge we have of what the children's specific needs are, now that they're actually receiving the services that they need, because they weren't getting the services they needed, they weren't even in the autism classes and programming until the time of trial, father would be able to parent in the future. I'd ask the court also to note that when evaluating whether or not this second part of the 15-month time and care ground was met, whether there's a substantial likelihood that he'd be unable to parent in the foreseeable future, I think the court does need to take a look at the record of father overcoming all of the deficiencies. I mean, the department had to concede at trial that everything that had been levied against father at the onset of this case had been remedied. He was diligent. I understand that the 15-month time and care is less about the parent's effort and more about the actual cold, hard results, but the results, for the most part, speak for themselves. He overcame nearly everything that was alleged against him, except for this new development, not a completely new development, but a heightened understanding of the children's extreme and more extreme behaviors as we grew closer to trial. And if father had had more time, his contention is he would have been able to remedy those circumstances. And the court's order, the trial court's termination order, is not reasonably supported by the evidence on this record. I'd ask to reserve the remainder of my time for rebuttal, if I may.
All right. Thank you, counsel. Ms. Lowe.
Thank you. May it please the court, my name is Lauren Lowe. I'm from the Attorney General's office, and I'm here representing the Department of Child Safety. I'd like to start by addressing the father's contention that the children's special needs suddenly arose at the 11th hour. That's simply not the case. As early as January of 2018, the foster parents were reporting to the Foster Care Review Board that there were, quote, constant doctor or therapy appointments, and that father hadn't attended any since October 2017. In January, Nikayla had a feeding evaluation. Wesley was regressing in his language. So it was evident that these children were beginning to demonstrate significant special needs quite early. And those special needs became more and more evident and more intense as the case went on.
But when was father put on notice that these special needs have to be addressed? I mean, just saying, oh, we took him to the doctors doesn't really do it for me anyway. I mean, there has to be, you need to correct this problem.
Understood. Yes, the children's special needs were discussed in numerous court reports, of course, but also...
when was the first one?
At least as of January, the court reports...
Of 2018?
Of 2018. The court reports document that Wesley was regressing in language, that Nikayla was overeating and needing feeding therapy. That really is when things sort of started to step up. The department met with father, the case manager met with father in March 2018. That's documented in a case note in Exhibit 24. The case manager emphasized to father that it was imperative that, among other things, he begin participating in the children's medical appointments. In the court report for May of 2018, Exhibit 11, there's a concern noted that father is not attending the children's medical appointments even though he is notified. And most significantly, in June of 2018, when the department was considering reunifying the children with father, they held what's called a team decision-making meeting. The people...
You said that's June of 2018?
June of 2018. And that's documented both in the therapist notes in Exhibits 22 and 23, as well as in Exhibit 12. The actual TDM notes are not there, but the results of the TDM are reflected in those documents. And what happened at the TDM was they were discussing what needed to be done in order for father to reunify with these children. And several conditions were placed on father. Father has testified that he agreed to those conditions, and he agreed at trial as to what they were. They were that father begin attending all medical and therapy appointments for the children, that he arrange a backup plan for when he would be unable to care for the children because his fiancée had her own disabilities, and she would be unable to meet the children's needs on her own. So he had to have a backup care plan in place. He also agreed, perhaps most crucially, to sit down one-on-one with the children's therapist, Amber Chudzik, who testified at trial about the children's numerous special needs. And what she was to discuss with him was exactly what those needs were and exactly how he would need to meet with him. They were supposed to form a plan as to how he would do this. And he scheduled the meeting, and he missed it.
Okay, so the children are taken into DCS care for certain reasons. Father addresses those reasons, but you're saying that at least as of June of 2018, he was aware that new conditions the department had become aware of that he needed to remedy unless his rights were to be terminated.
I would agree with that for the most part. The domestic violence that was raised at the beginning of the case did seem to be resolved. He engaged in counseling, and his new relationship did not involve any domestic violence. The concern of alcohol abuse was remedied by his continuing to primarily test negative and testing negative for long enough that they discontinued his testing. However, he did continually throughout the case and at the beginning demonstrate a stability problem, instability in employment. He had a number of jobs throughout the case. and was constantly changing schedules, which was a problem with scheduling the children's appointments because he would change jobs when an appointment was already scheduled, and then he wouldn't be able to make it. And his housing. His housing was a continual problem throughout the case until he secured housing in October of 2017. However, as was shown by the parent aid notes, from the fall of 2018, his housing may not have been appropriate for the children. There was a snake and a pit bull, and there was a foul odor in the apartment that actually caused them to have to move the visit outside for the day.
But the Superior Court never made any factual findings on these points.
The Superior Court did actually make factual findings regarding the visit being moved outside.
Can you refer me to a page, please?
Yes, I can. It is on page, let's see, hang on. There we go. It's on page 12. In the middle of the page, in October 9th, 2018, father's in-home visits were stopped because his apartment had a foul odor and roaches were present. Father maintained the new neighbors for the cause.
Okay.
But you're right, that other than that, his housing was not a significant focus of the court's order.
And now I'm going to ask you similar questions that I asked Mr. Jones, and that is, when we look at Judge Anderson's order, he makes a lot of specific findings as to mother.
Yes, he does.
Very few findings under the statutory basis as it relates to father. And then most of the findings that arguably support a termination are made in the best interest analysis, which is a different evidentiary standard. You agree with that?
2 points. Certainly, his findings regarding mother were far more extensive. Mother's problems were significant. However, the court did address in the grounds section of his order on the bottom of page 18 that father's behavior under stress and ability to care for special needs children is a concern.
Okay, well, that would, because it's a concern, doesn't say to me that I'm terminating your rights because of my concern. That would be inappropriate, wouldn't it?
Indeed. I think that a simple concern is not enough. However, I think that
Isn't
when
that
you
a
take
concern with any parent who has a stressful job? That's a concern. How does that translate to a finding by clear and convincing evidence?
So it also proceeds onto the top of the next page to note that the most recent assessments of father's parenting ability disclose a number of parenting concerns. I think when you take those findings in combination with the findings in the best interest section, it's clear that the court was aware of...
You know what they say when people say it's clear? That it's not?
It's not clear.
We normally say, you have to make these findings, and you have to make them by clear and convincing evidence. We don't have those findings. And the only finding I think supports a termination is what we discussed with counsel, and that's the father and it's a fiance or wife
Fiance.
are collectively, individually and collectively unable to provide specialized supervision and care for the children. But that wouldn't be by clear and convincing evidence, would it?
Your Honor, it's actually unclear in the order what burden of proof he found that particular finding by. You'll note throughout the order that he does not specify, even at the beginning of the order, what the burden of proof is. He only states the burden of proof when he makes the ultimate conclusions that sort of parrot the statutory language.
It's under the best interest section.
It is under the best interest section.
And he does mention what the standard is for best interest.
Yes, below. Yes. I would also point this court to...
So you want us to nevertheless find that that's a finding by clear and convincing evidence, even though it's in the best interest section and he discusses the standard for best interest as being preponderance?
I think it's an indicator that his reference earlier to the concerns did indeed rise to the level of being unable to parent. The court, it's longstanding case law from the Arizona Supreme Court that the court is been deemed to have made every finding necessary to support the judgment. And in Mary Lou C., this court held that the court may examine the record to determine whether the facts support an implicit finding. So to the extent that his finding was not explicit, that it parroted the statutory language, that he was unable to remedy these circumstances, this court can infer those findings. And the record clearly
hold
supports
on,
them.
because the department argues ad nauseum that we can't substitute our judgment for the Superior Court and we don't reweigh evidence. But that's exactly what you asked us to do just now. For us to look at this evidence and reweigh it and determine that it's by clear and convincing evidence, even though Judge Anderson puts it in the best interest standard for something less than that.
But Judge Anderson also implicitly found that father had been unable to remedy the circumstances and that there would be a substantial likelihood that he would be unable to remedy those circumstances in the near future. And this court is authorized to support the record to determine whether the record supports those findings.
But that would require us to go through the record and determine what evidence is to believe and what evidence is not to believe, especially since Judge Anderson doesn't give us a clue on what he did to reach that result.
Well, I think he does give us quite a bit of a clue in the sense that he focuses on father's behavior under stress and ability to care for special needs children. And the record does reflect, particularly in the latter half of 2018.
But when you talk about a concern, that just seems very different than a finding by clear and convincing evidence. So he does talk about concerns, but that seems like everyone would have their children, the rights to their children take away if a concern is all that we need to have.
Well, the court is presumed to know the law, and the court is presumed to know that the burden is by clear and convincing evidence to find those specific statutory factors, and so the court can imply those findings.
If you put him in the right section, I mean, that's what I'm struggling with is he lays out, I mean, he goes on in great detail about mother, and he lays out section after section, and he goes through this detail, but he doesn't put the findings for father in the right section, and he doesn't even use verbiage that even indicates that he uses, I have concerns. Well, that's not enough. And yet we're supposed to go through the record and say, oh yeah, there's plenty of evidence to support it. Why shouldn't we just send it back and have Judge Anderson tell us if there's plenty of evidence to support it?
Well, I think what Judge Catani was referencing earlier during Mr. Jones's argument is particularly relevant. Kind of to what end are you sending it back? Really, what is missing are the recitation of the statutory findings. So if the court had found explicitly father has been unable to remedy the circumstances and there's a substantial likelihood that he'll be unable to remedy them in the future, that this would be a sufficient order. That is exactly what would happen if this were sent back, and so to what end? But moreover, the court doesn't even need to reach the findings issue. Father had the opportunity after this ruling was issued to challenge the specificity of the findings, and he failed to do so. And so this court does not need to address it because he has waived that claim.
Is it because he didn't file something with Judge Anderson?
Yes. Yes,
And
he did not give the court below a chance to address that. Instead, he raises it here when we're months down the line and it would prolong the children's stay in foster care.
Haven't we addressed the notion that if there's insufficient findings in a more recent case, we said we're going to send it back?
Are you speaking of the Logan B case?
Yes.
So I think this is actually the opposite of Logan B. In Logan B, there were no factual findings whatsoever. There were simply the legal findings. And this court has held that one of the significant reasons to require the findings, setting aside the rule requirement, is to enable effective appellate review. Here, there are actual factual findings. It's simply the statutory language that is not present. However, the court's presumed to know the law, so we can presume that Judge Anderson knew what the law was, what the requirements were. And there are factual findings here that can enable this court to conduct effective appellate review. I'd like to address Mr. Jones's contention about the recommendation of the family reunification team from I believe that was the July FCRB report. It is true that there was a family reunification team potentially on the table. They were discussing that at the June 2018 team decision-making meeting. However, a substantial amount happened between July of 2018, when that FCRB happened and when that case manager supervisor reported that he was doing well, and September, when the termination motion was filed. Father missed the meeting with Amber Chudzik, the therapist, which was perhaps the most important condition of his reunification. He needed to know in detail what those children needed. And Ms. Chudzik, as is clearly evident in her testimony, is one of the best people to learn that from. She can state in detail not only what these children's diagnoses are, but what their practical needs are. Additionally, he missed a number of medical appointments that month. Wesley's feeding evaluation had to be rescheduled because he did not come with supplies. There are a number of communications in Exhibits 24 and 26, which are case notes as well as emails, during that time frame where Father is informed well in advance of therapy appointments. And in fact, some therapy appointments were changed explicitly to accommodate his work schedule, and those appointments were missed nonetheless. So Father demonstrated no real forward progress at that point. In fact, he was regressing. So to the extent that there was a family reunification team in play at one time, well, that was taken off the table by that point because Father had been told, this is what you need to do. And he couldn't even do it for a matter of 3 months.
So I want to ask you a question. The department's obviously an expert in dealing with these cases. And when you got this, not you personally, but when the department received this order and you read through it and you notice the things that we've discussed about how it was in the wrong section, why wouldn't the department make a comment to the judge that maybe he needs to clean this up a little bit? I mean, you put the burden on the father, and I understand that, but you're the experts. This is your case. Why wouldn't you say, Judge Anderson, there's nothing that prevented you from coming into Judge Anderson and saying, hey, you made this finding in the wrong section. It's really the statutory ground section, and you should clean this up. I mean, you even provide proposed findings of fact in some cases.
In some cases, yes, upon request from the court. Obviously, I was not the trial attorney. I can't get inside their head, but I would say that because there was sufficient findings. It was clear. There was only one ground.
Well, you candidly admit that there was, in your brief, that there was some problems, and you ask us to make some inferences to correct the problems. But this is candidly something that the trial lawyer would have known just as well.
It is certainly possible that the department could have done so. It did not do so here. But there was one ground alleged. The court found that ordered the termination. Therefore, it was clear that the court had, in fact, made the requisite findings. And that's likely the reason that was not done.
All right. Thank you.
And if you don't have any more questions, I will cede my 15 seconds here.
All right. Thank you, counsel.
Thank you.
Mr. Jones.
Thank you. To address the Logan B case, the department's asking this court, it's saying to this court, that case was different. There were no findings. It's inappropriate to presume findings. In this case, the findings are in the wrong place. Some of them are implicit, which means there are no findings. The department is asking you to do the same thing, to presume things that aren't there, to presume things that are in one place, could have been written in another place.
But your client does have an opportunity to say these findings are inadequate. I think you've got to do something that would show that there's clear and convincing evidence. This is a pretty straightforward ground for severance. The 14 months, the time in care ground is not that complicated, and so it seems like it is something that if the findings are inadequate, why not raise it with the trial judge and say you haven't even said that there's clear and convincing evidence that I can't remedy these circumstances, or that there's a ground for severance. When the time in care one is kind of an obvious one. It's that they're still in care, and it seems like if the issue is simply the inadequacy of findings, it seems like there is a reason for father to raise that issue below with Judge Anderson.
Yeah, I think certainly they could have. I'll note that father was represented by a public defender who typically their contracts do not include appellate work. They typically process the trial, and when they lose, they file a notice of appeal and hand it off. And of course, doesn't excuse what they're doing. It shouldn't save father, but I don't think he should be penalized because his attorney that he's going to for legal expert advice says, hey, we're going to send this up to the Court of Appeals. Judge botched this, and the Court of Appeals is going to set it straight. Additionally, I'm not certain exactly through what motion they would do that. There's not really a motion to reconsider available under the juvenile rules. When they borrow from the civil rules, typically there needs to be a change of circumstances.
But even just to request findings, to request specific findings, you certainly can do that before the findings are made. If there's a concern, there's a complicated area, I'd like specific findings regarding this ground for severance.
And there's also just a common sense reason that may not help my client, but it's basically, they already knew what Judge Anderson's opinion was, saying, hey, if you could clean this up here, here, and here, you'd have a much tidier order. I mean, it's sort of working against yourself to point out to the judge all the ways they can fix the order that terminates your rights, especially if you intend to take it to the Court of Appeals.
We're talking about the best interest of a child, and as the state just pointed out, okay, we say, oh, yep, this order is void of correct findings in the right place, so we're going to send it back for additional finding. The child is still in limbo for an additional period of time, and we're back here, what, a year from now with a tidier order? I don't see a clear path here.
Father's asking that it be reversed, and if that entails first sending it back to Judge Anderson to see if he can indeed reconcile the pile of evidence that shows father making changes, the evidence showing the department failed to offer services required under the statute to address this lingering concern of father dealing with the children's behaviors. Judge Anderson has to actually stick that in the right section, do it by the right standard, and it needs to be there. It needs to be able to speak for itself. So I don't think it's a waste of time, even if it's just going back for Judge Anderson to fix the order. I don't think that's a waste of time, and father wouldn't think it's a waste of time to have at least a clear order that shows why and when and for what purpose and with what evidence his rights were terminated, especially because father still has the right, if it goes back and Judge Anderson does something else with the findings, I mean, father still has appellate review rights going forward. The department noted that after that meeting at which DCS said we will be putting in a family reunification team, which implies putting the children in the home with father, that many things, that a ton of things happened right after that. In the next 2 months, the main thing that happened was the case manager changed. Got a new case manager, and all of a sudden the theory is we need to terminate this parent's rights as soon as possible. During that period of time, father participated in numerous medical visits and numerous administrative appointments. My brief on pages 13 and 14 points out several of the appointments that he attended, and I'd ask the court to look at that. He was making an effort to comply with those. He wasn't invited to half of the visits, half of the medical appointments, because mother got to go to those and he didn't. Many of the therapy appointments that were just starting to develop and be put into place nearing the getting closer to trial, took place in the placement's home, and father was expressly not invited to those either. So he was at a disadvantage in understanding the most up-to-date diagnoses for these kids and what their needs are. It's true he missed one appointment with a therapist. That's on him. He shouldn't have missed that. But to terminate his rights because he missed one appointment, I don't think, or one appointment with a therapist isn't appropriate. The Judge Anderson, several times during this case, refused to sign ASPA reasonable efforts findings for the department when they requested them, because the department had failed over and over again to timely put in appropriate services. Specifically, there are numerous requests from father at hearings leading up to the trial where he had begged the court to direct the department to do a better job of informing him of appointments, of scheduling it in appointments at a time that he could actually attend, making sure he had timely notice. They complain about father's stability, and he did struggle with stability at the onset of this case. It was a victory for him to have employment towards the end of the case, throughout the end of the case, but he struggled. The department notes in their brief that in 1 week, father missed 5 hours of medical appointments for one of the children. How's he supposed to maintain his employment while he's got these appointments made by someone else at a location that's inconvenient to him with little notice and maintain his employment? Father is asking this court to not to reweigh the evidence, but to take a look at Judge Anderson's inadequate order and to see that not only did he not make the requisite findings, the statutorily required findings, even if he made them implicitly, they're not in the right section, they're not by the right standard, and there's no reasonable basis, no reasonable evidence when the whole record is considered on the whole to affirm this case. So we're asking that it be sent back or that it be reversed. Thank you.
All right, thank you, counsel. The matter is deemed submitted. We'll issue a decision in due course after consulting with Judge Campbell.